But I have not taken this matter lightly. I've spent a lot of time. We created a solar law. This fits the solar law. There's no variances, and I believe, I've talked to Ryan, I've talked to the town of Wheatfield. He took the town of Wheatfield law and made it even more stringent.
Town of Wheatfield took our original law.
Yeah, right. We copycated it, so, and we added to it. Some of the things Tobin wasn't happy with, but we tried to sort it out. So, that's my feelings on it, and I'm ready to move forward. But
Steve, can I comment on one thing that I think is extremely
hold
important?
on 1 second. I don't know if Councilman Morale wants to say something.
Now, in that master plan from 2011, now this law, 6 months old, we put in, how does that coincide with a 7-year-old master plan? That's where I'm
I
getting.
mean, the master plan is in place. It kind of, again, it guides those decisions, but it's not the be-all, end-all of land use in the town of Lewiston, because the board makes certain decisions and makes certain findings. Now, obviously, the board may disagree with, Tim Masters on the impact of the project and how it fits in with the solar company would disagree with how the project fits in with the master plan. And I bet you if you gave them the opportunity, they would say, it fits in the master plan for X, Y, and Z reasons. And obviously the neighbors see it differently because they view it through a different lens. You're always going to have that difference, especially when you're looking at, and this is what I was trying to get out earlier, but it wasn't quite eloquent enough, is when you're looking at something from that macro level, like you're always going to be able to argue one way or the other because you can't get down and dirty in the specifics. You leave it kind of open and broad so that it guides your decision, but really it's very project specific and how you feel that impact of that certain project. So again, the neighbors obviously think the project is against the master plan, and I'm sure that the solar company, if you gave them the opportunity, would say it absolutely fits in with the master plan for whatever the reason might be.
The master plan is a guideline, and we have overlay districts that cloud the issue. Do you recall when we went down to the training on East Aurora, someplace down there, they were talking about how this is the way to go. It's a green project. New York State's encouraging this. You better have something on the books, and we had nothing. And then we were alerted that some of the companies had sent out flyers or letters to some of the property owners. So the first thing we did was have a moratorium to stop any projects while we put together our law. And if I'm correct, and Ryan, you could jump in, and historically when towns don't move ahead with different projects or they're overly resistant, the state takes over. They take away our home rule. And so we diligently put this together. We had public hearings on it to discuss it. And in that whole training session down there, and Steve gets a kick out of me, I always talk about the unanticipated consequence. What is going to happen that we're not aware of? And one of the things we're not aware of is that the farmers in that area, residents, cherish their land. They want to protect it. And I can see their position. I also see the position of the particular applicant who owns property. He's put together a project. He's asked for no variances whatsoever. So it's passed how many different levels of our bureaucracy, I'll be less cruel, of our governmental procedure on how to get this through. And asked for no variances, no special privileges whatsoever, and dotted all the I's and crossed the T's. So we got a tough decision. And we talked about, they called it solar farms. That was the first one. So why are they calling it solar farms? Because they have to be so many acres big, and the only place you're going to find the acreage is most likely the rural parts of your community. And it's a term that is somewhat conflicting.
Anything else?
I'd like to ask Al something. Al, if we were to kick this down the road for another meeting, to what end? What are we trying to achieve?
Don't know. I mean, I guess. I appreciate that you asking me that.
No.
what I would like to achieve is perfection in the plan, but we're not gonna get that. I think one of the things that I found necessarily deficient, in my mind, I try to put myself in the position of the homeowner, is that if I'm gonna have a screen, and again, this is something that's subject to criticism and or addition, and one of those trees dies, one of the trees falls down, I would want a 1-800 number to call to have someone put that back up right away, because if it's there and I didn't want it there in the first place, and a tree goes down, it's just an added reminder to me that it's my backyard. And so that would be one of the things that I would like to add to make it closer to perfection as far as the plan is concerned. Also, I was thinking, I mean, I think they said they mowed it twice a year. Again, I unfortunately bought a new lawnmower this year for my son to mow the lawn, and that didn't happen. So I've mowed the lawn more than I care to think about, and I can't imagine, I want to plant that grass in my yard if I don't have to mow it twice a year. So that would be perfection. I mean, unfortunately, I've been on this board long enough to know that with enough time, you know, both sides are going to come back with petitions and more signatures and and I don't think it makes the decision any more difficult or any more easy. You know, I think we have the same problem that was outlined by Mr. Guyman. I think it's just a difficult decision that we have to make.
Let me ask Mr. Parisi, if we, as a board, voted against it, said, no, we're not going to do it, who would sue us? No, I'm serious.
To be honest, I've asked them that question, and both sides can sue us. If we approved it, the citizens could sue us, and if we disapproved it, Borrego could sue us. So they both could sue us. Article 78, both, correct? And that's what I talked to Ryan about.
Right.
You know, I asked him the what ifs. So, yeah, like I said, I haven't moved on this lightly at all. I've taken a lot of time, a lot of sleepless nights. You know, I'm friends with Cindy Sonoyan. You know, I even referred to Rob Moriel in the Peach Festival Parade. The longer we do this, the less people are going to wave back at us when we wave to the citizens along the way. So,
They wave at you, Steve, don't worry.
yeah, right. So, you know.
The gesture just might change.
Yeah, right.
Yeah.
Go ahead.
Just, I mean, I worked with Ryan on the solar law.
Can't hear you. Just
Yeah, you said your agenda.
I worked with Ryan on the solar law, and as far as being the planning board chairman, when we reviewed that, we looked for, you know, compliance with the solar law to make sure that it did fit. And I guess from my opinion from that standpoint is that, you know, we created the law to make sure that if something were to go in the future, and there's probably going to be more eventually, because it's becoming more of a popular thing. But we wanted to make sure that we had provisions in there to protect, you know, residents and property owners around the area where the project could be located. And when this project was presented, they did everything that was required within the law. And so that's why I think it's going to be difficult to say we can't do this, because of the fact that, you know, if we create a law and the applicant abides by the law to the letter and then some.
Well, that's where I think Mr. Jacoby at the last meeting said, you know, he wishes more people were at the public hearing on the law. And I discussed it with Tobin when we talked to Mr. Sanger, you know, because we created a law. We created a good solar law. I feel, Tobin might argue with me, we created a good law, and everything's been abided by. So it's kind of puts us in a tough situation, I mean, you know, to make a difficult decision.
And as, you know, as the entire board knows, I have large solar panels in my backyard, servicing my home. And, you know, there is no noise. I don't, you know, no one notices the children play around it. They haven't grown a third eyeball or anything.
How many panels is that? How many panels?
It's 120. It's basically the size of it could probably run, because they have 6 kids, it could run like a small retail.
It was your choice to put it on your property. We're not getting a choice in this matter at all.
No, I understand that. I'm just, as far as.
I'm just saying, yeah.
Well, I'm just saying too, that
Yeah.
there's both sides, and there's benefits to the solar law, there's benefits to having solar, panels, whether they're on your roof or in your yard. And it all depends on how you look at it. And I understand, how their perspective as well.
Bill, let me ask, Bill, did you receive complaints from your neighbors either while you were putting it in or since it's been up?
My neighbors don't even know it's there, really. I mean, I have 3 acres,
Right.
but.
It's all
there's-
Well screened.
But it's screened because it's just, we don't cut in between our properties. I mean, it's.
How close are your
Hold
neighbors?
on, hold on, Tobin, I'm gonna give
Are
you
they
one
right next door?
one last
Couple
thing.
hundred,
to-
well, the
to
neighbors
talk-
up
hold-
front,
hold on.
they're within 100 feet.
Okay, I'm gonna give you one last
If I can
opportunity.
clear the air, I think it's obvious, everybody in the room knows, we don't want to see a headline in the Gazette or the Buffalo paper that says, Town of Lewiston against solar panels, Town of Lewiston anti-green. Borrego is in this for money. I'd like to see Borrego make money, not at our expense. There's plenty of other areas in the town of Lewiston as dictated in this plan where this is supposed to go. And you as a government body are supposed to consider that. You can't mandate where it goes and say, well, we want one here, we're gonna wait till it comes here, or it's not gonna happen at all. But this is supposed to be guiding you. The problem is you guys created that law, and it's in conflict with this. It is, let's be honest,
Well,
it is.
Things change, I mean,
And
things change.
and this is a 20-year plan for 2030, for 2030, and things do change, I agree with you. You have a difficult task ahead, but let's be clear about this. Borrego profits, Tim profits, they leave, they go back to New York, wherever, they create another one. We're here, we're the community in here. So you had that struggle with the law that you created and the people that have to live around it. I don't know how many people see what you have. I don't know how it affects their property value if they complain to you. But we do see it, we will see it, and we are here to complain. But as far as the town's, when, Ryan, when you were talking about the legal aspects of this, and who can get sued, nobody wants to see it come to that, and I think it would behoove Borrego to not do anything like that. They're supposed to be working with communities. Green is supposed to be good, clean. That's the last thing that they need to do is to sue a community that said, well, we don't want it here. We don't have a problem with you putting it somewhere where people are going to complain about it. But we don't want it in our front and backyards where we are. I mentioned to the board, I've been in areas where there are farms much larger than this one. And they were in vast farmland expanses with no homes. The home that was on the farm was a little bit dilapidated, a little bit beat up. But no doubt the owner made a bit of money. Good for him and good for Tim. But it's at our expense. I'm sorry you guys are going to have to struggle with this from a legal perspective. I would ask that you table it. And I think what Al was touching upon is what happens if you table it. It doesn't go away, it festers. Each side gets emboldened. All I would like to know is that everybody reviewed this. I'd gladly give you this, Mr. Jacoby.
I have access to it.
If you have access, I would only ask that you, because you're supposed to be using it in guiding your decision. And it ultimately leads to your legal decision, CYA, right? You have to cover your bases. Well, this is the lesser of two evils. Borrego, from out of town, or us, for 25 years.
Thank you, Mr. Gormley.
That's Bill. Good job, Bill.
So, moving forward, okay, discussion, what do you want, where do you want to go? Well,
Well, let's go with Robert's rules. Okay. Can we do nothing under Robert's rules? Or do we have to have a motion to pass or fail and a motion to table?
You have to have the motion.
So you need a motion to pass it or to reject it. If you have a motion to reject it, you have to have a reason in that motion, right?
So I guess going backwards, technically your first motion is on seeker, because your approval motion can't occur until you made your seeker determination. So you would make your motion for seeker. And then you could table seeker, you could do seeker tonight, you could move on to your approval motion. I mean, functionally, how you want to do it.
Does this motion need to be read into the record?
The seeker motion?
Yeah.
I think there's things that need to happen before then, but if you're ready to move on the project tonight, we do seeker first. If you're not ready to move on the project tonight, you know, seeker waits as well. I mean, you could do seeker tonight and put the rest off, but it doesn't necessarily make sense to me. Do it all at once.
Just for the record, Niagara County has approved this.
It went to the planning board, I believe, correct, Chris?
Yep.
Right.
Niagara County Planning Board?
Niagara County did, the Environmental Commission did.
Planning board, so.
Did that go to zoning?
No.
Did not go to zoning?
No, no ZBA, there was no variances
no
requested
changes
or
or
anything like that. So I guess at this point, someone can make a motion to approve if there's to approve seeker, yeah, and if someone wants to make a motion to table that, that's what. And what I was saying was going into that, I think that for the record's sake, we should have the town engineer go through seeker, explain the impacts were identified and the determination of those impacts.
That has not been done already?
Seeker has been filled out. The town board ultimately rules on seeker.
Right, yes.
Seeker has been filled out, it's been done, it's been submitted, our engineers have gone over it. Before you can approve a project or deny a
Right.
project, I guess really approve it, seeker has to be done. And that has to go first. So it's been done, but it needs the final
Right,
motion and
okay.
approval from the town board.
Okay. And there's no grounds that we could delineate to reject seeker.
I would defer to engineering on that.
Mr. Landon, sorry?
My turn. I'm sorry, what is the question?
I would just go through seeker. I mean, if that's where you're at right now.
Well,
it's-
we have say I make a motion to approve seeker. We go vote, it's approved. If I make a motion to reject it and say it has a positive impact, I would have to state a reason.
And that's why the engineer should
Right.
go through seeker right now.
Right.
Explain it to.
Before any motion?
Yes, explain it to the board,
Right.
and then you can make your motion.
I have the process right, but I'd like to hear it in the record.
Understood.
Yes.
So I'll go, okay, here we go. You should have in front of you what is included as part 2 and part 3 of the environmental assessment form. You may want to
It's been provided.
grab
in the
that.
file. I don't know if it was in their packet or not, but it has been.
I saw it earlier.
The town has it.
I did.
Previously.
Okay. So, and tell me if you want me to change the approach here, but all I'll offer is, we went through part 2, okay, where I believe there are 18.
Long form.
Long
So,
form.
just to be clear, they did do the long form, environmental assessment form, not the short form for this project. It's a more detailed, seeker form. It's a little more detailed in the information you can get and what it's looking for.
And on that document, it shows no negative impact, correct?
That's our opinion, yes.
And the environmental commission reviewed it, and they determined there was no negative impact.
That's my understanding, yes.
You want him to read the
Yeah.
seeker?
No, I think as long as he's indicated that the seeker form says there's no negative impact, and you reviewed it and you concur.
Well, I will go through it.
What I'll do is I'll offer to summarize our thoughts and opinions on the matter. There's 18 questions in part 2 of the environmental assessment form that you either have to answer yes to or no to. If there is an impact, then you go through and determine whether there is no or a small impact, answer specific questions, or if there is a moderate to large impact that may occur, okay? So we went through that, and I'll summarize the areas where we felt that there was a moderate to large impact that may occur, and any mitigative measures that we thought would be in place or could be put in place to mitigate those impacts, okay? So the first one will be impact on land and surface water, okay? I'll just read these from the part 3 we prepared. The proposed action may result in increased erosion from the physical disturbance of the land during construction. However, the project is required to have an approved stormwater pollution prevention plan, I'm sorry about that, which requires the installation of appropriate stormwater controls to mitigate the potential for erosion and drainage impacts. So there we identified a potential, we said what the mitigation was. Also under impacts on land and surface water. Item number 2, the proposed action will impact a federal wetland with the extension of a 15-inch diameter culvert pipe under the proposed access road. However, the project will require jurisdictional determination by the U.S. Army Corps of Engineers and will be required to meet any permit requirements in order to mitigate potential impact of wetlands. Under the same subject, the proposed action may create turbidity in a water body from upland erosion during construction and affect the water quality of downstream water bodies. However, the project is required to have an approved stormwater pollution prevention plan, which requires the installation of appropriate stormwater controls to mitigate the potential for erosion and drainage impacts. Okay? I'll save impact on agricultural resources to later, but the next item would be impact on aesthetic resources and community character. The proposed action is substantially different from current adjacent land use. However, the solar energy system is situated to the rear of the proposed site, and the town has mitigated visual impacts to adjacent residential properties by requiring appropriate buffers. Next one, impact on noise, odor, and light. The proposed action will result in an increase in odor and noise from heavy construction equipment during construction. However, the related impacts are temporary and limited to construction of the solar energy system. After construction has been completed, there will be no noise or odor impacts related to the operation of the solar energy system. And lastly is impact on agricultural resources. The project will convert agricultural land within the agricultural district to a non-agricultural use. However, the solar panels will be installed on pole screw foundations, which minimizes soil compaction and limits the overall impact to farmland. In addition, the project will be required to file a notice of intent with the New York State Department of Agriculture and Markets to further evaluate and mitigate any adverse impacts identified by New York State Ag and Markets. And what I would offer is that if, should the board consider, would be to make the requirement that the project be constructed in accordance with New York State Department of Agriculture and Markets guidelines for mitigation for solar energy projects. Revision was dated April 19th of this year. So having said all that, it will be our findings that the project will result in no significant adverse impacts to the environment, and therefore an environmental impact statement not need to be prepared. Accordingly, this negative declaration is issued.
That's the recommendation from the engineers with the explanation for each of those. At this point, I could read a motion to the board. It would be basically, I guess, a motion to approve that seeker determination, and then the board can take their action to table that or vote on it.
Okay, following Robert's rules, just so that we move ahead with this, all right? Bob, you're gonna have to help me with that New York State agricultural title. I move that.
I actually have
You got it?
seeker resolution prepared. It's on everybody's desks. So this is a seeker resolution regarding the Town of Lewiston application for special use permit and site plan review for utility scale solar energy system at 1897 Swan Road. Whereas Borrega Solar Systems, Inc. has applied to the Town of Lewiston for a special use permit and site plan review for a utility scale solar energy system on a property located at 1897 Swan Road. And whereas coordinated review has taken place and no other agency has objected to the town board assuming lead agency and the time for such comment or objection has passed. And whereas a full environmental assessment form, part 1, having been prepared and filed with the town by applicant, and whereas a full environmental assessment form, part 2 and 3, having been prepared and filed with the town by the town engineers, and whereas Moderate to large impacts were identified in Part 2 of the environmental assessment form, and whereas the town has reviewed the full form environmental assessment and has otherwise assessed possible environmental impacts of the proposed action with regard to each of the considerations listed in Part 2 of the EAF environmental assessment form, now therefore be it resolved that it is determined that the action will not result in any significant adverse impacts on the environment, and it is directed that this determination pursuant to SECRA be prepared and filed. So we would need a motion to approve, a second, and then a vote if you're going through, or a motion to approve with another motion.
I don't have Robert's rules memorized, but if I'm correct, if I make the motion and Al seconds it, somebody else has to make a motion to table it. We can't table
Somebody
our,
else would have to
we
make that
cannot
motion.
table our own motion.
To table.
So I'm alerting the board to what they may have to do if they choose to do it. What the ag district does not need to be included in this.
Not in this SECRA resolution.
Motion.
It
To
would-
move this along, move for approval of the SECRA resolution as read by the attorney.
Second.
We have a motion and a second. Any questions? All in favor?
Aye.
Opposed?
Let's start. Okay. Now, this is the tricky part, all right? My recollection of Robert's rules is that if we move to reject the application, we have to say with cause for the record. You can't just say, I don't like it.
Well, the town board in this particular situation needs to make findings. I mean, you're gonna vote on a particular resolution, there will be findings as part of that resolution. So,
That would be to accept it.
that would be to
Accept it, but if we,
or to deny it. I mean, you're making findings either way. Whether you're making findings both ways. Whether you approve or deny it, findings need to be made by the town board.
Okay.
all right, I do have one more question. In the past, we've inadvertently forgotten to include something in a resolution that's been part of discussion. For example, we have the buffer, we have talked about screening. And is that in this resolution?
So,
Because that was added extra after the applicant
that's
application.
correct. So, prepare general resolutions for this with a section where conditions can be written in.
Last page.
Yes,
Because obviously conditions are always going to be
right.
changing or fluid changes. So there's a spot for conditions to be.
Should we add those now?
I would, if someone is going to make a motion to approve, I would talk about the conditions so that the conditions could be included absolutely in that motion to approve.
If I may turn to Mr. Conrad, you're part of all the discussion in regards to this project. Are there conditions in addition to the buffering and the agricultural clause that Mr. Langman referred to that should be listed?
There were none other listed on these planning board documents.
Mr. Conrad, on the vote at the planning board, was it unanimous?
Yes.
Mr. Supervisor, would the additional conditions be forever green screening, dense forever green screening?
The way I looked at it was buffering consistent with the landscape plan that was submitted with continuous live vegetation. So if something happened where when a tree died, we would be able to contact them and replace it.
I guess, but the concern about that would be the nature of that screening then. So if you've got a tree in the winter that loses its leaves, it's going to lose its.
No, but as long as it's alive, continuous live vegetation.
I'm not satisfied with that. It's got to be forever green, it's got to be relatively dense, and it's gotta be relatively high. So, those are the three things that I've been
And I'd like
struggling
to
with.
add my fourth requirement, that it be, that there be a means of communication with the company to replace any holes or vacancies
I
that
think-
they're in parts of
I
that.
would think if a resident had a concern, they should go right to our staff member, Chris, because that's his job to make sure it's done right. And if the neighbors aren't satisfied with it, they need to talk to the neighbor, then
So
talk to us.
we would then reach out to the company to
Yes.
mitigate that issue. What kind
Because
of
the company
enforcement-
may change
What kind of
names over the
enforcement do we have on something like that?
You can bring them in and revoke the special use
Okay,
permit if they're not.
based on-
if
based
they're
on-
not living up to the
Well,
terms.
the height of the fence,
Don't have the fence.
The
vegetation should be, the height of the fence that's around
Right,
the structure.
sufficient.
I'm not seeing, Brian, bonded for decommissioning this. Is this? is
That's a
it-
requirement of our code, so they won't get permits unless
How long is that bond good for?
the bond is forever.
Who pays that?
They do.
Borrego is responsible?
Yep.
And is there an escalator clause in that?
Every 5 years, I believe it gets reviewed, or they have to submit a new decommissioning plan that obviously the town reviews.
And the bond will be part of that.
And the bond is stated as part of that. If the anticipated amount of decommissioning increases, then the bond needs to increase with that as well, or again, we can bring.
Bond is 150% to it.
I believe that is correct. It's meant to be beyond what it would cost to decommission the
One
plant.
of the highest.
The anticipated cost of decommission.
Okay, I have one more. I talked about this before, well, I actually have two. I talked about whether the facility drops down with usage. And I would like to say if it drops down to 25% usage, it would ignite a review again. So we have to look to see if we want to renew their special use permit.
How do we gauge that? How do we-
That's how do you police that? Is
Well, would we not be getting a record from the
No,
company? No?
We would monitor regularly.
Okay. Well, then,
Yeah, I mean, I don't think we have a right to see.
well, we can actually, we will know whether the reviews come up, if the facility is being used or not, because there'll be publicity on it, but part of the review. The other thing, I'd like to have a review for the special use permit, if it's a change of ownership of the company or a change of ownership of the property owner.
We talked about that.
Because if Mr. Masters sells it to somebody else, then you have to have a review at that point. If the company changes hands, we have to have a review at that time to make sure everybody's on board with what we believe we have addressed.
Ryan, how would we include that? What would be the legal?
So
That would include an acquisition too.
it would require reapplication for the special use permit, I suppose, at that
At
point
that
in
time.
time, when ownership transfers. Practically speaking, again, that's something that I don't know how you can enforce that, how you can tell someone they can't sell their property.
Well, they can sell it, and the company can be acquired, but then we just have a review for the special use permit to make sure they understand exactly what the town expects of
So you're
them.
not saying a reapplication,
No,
but a
just-
review to ensure
Right,
compliance
Compliance.
with the town code?
yes.
Yeah,
Does that make sense, Joe?
And those conditions. I think that's a reasonable condition, quite
I
frankly.
just think of the nightmare of banks.
I mean, it doesn't
The
require
last
reapplication,
20
yeah.
years, when banks have changed hands, and we've had zombie houses sitting around, nobody knows who they own. So if this changes ownership, we get to review it.
I mean, what do you mean by review? I mean, you review its continued compliance with the town code.
Yes.
But are we doing that annually anyway?
Not annually.
Every 5
Every
years.
5
So they
years.
have to resubmit a decommission plan every 5 years. But I mean, any type of code violation would be brought up on an as It's a violation
It's
by
a curb.
business.
But a sale of the property or sale of the company isn't really a code violation.
No.
So it would be more like Councilman Guyton said, a review to ensure compliance with our solar law.
Just to get them in front of us?
Yes. So who the principals are.
So what I would say there is upon change of ownership, or change of ownership triggers a review of the project. Do you want it to be in front of the town board or the planning board?
Both.
A review of the project first by the planning board, then by the town board to ensure continued compliance with the town code
As it is done.
and the conditions of the special use permit as passed.
Joe,
Mr. Supervisor, may I ask a question?
No.
Just a question,
No,
sir.
no. So, anybody else want to add anything? Okay, John?
I got nothing.
Okay.
My concern about the height,
Well, our code calls for 20 feet, and it will be 8 feet. Our solar law allows up to 20 feet.
I'm just talking about of the buffering, of the forever green.
Oh, I'm sorry. I think it's the height of the panels. Okay.
I don't want it to be
I think
unattainable,
the kind of the term you used was dense
dense.
and sufficiently high.
I would say at least equal to the chain link fence.
Right.
And if anybody wants to know, get a visual, I think of, go up by St. Mary's Hospital. The hospital is abutted by Fairway Drive. That is a very appropriate dense vegetation there. You would be in the backyard and not know there was a hospital there unless you looked way up.
The vegetation that they had proposed was spruce trees, like, to start.
Yeah.
But they will grow. Yeah, they'll be,
Is it on a berm too? Okay, so
No berm. Yeah. The berm was for arborvitae, in my opinion, but when I saw the landscape plan, it looked sufficient with the trees that they were putting in.
Ryan?
I just want to make sure that I have written down all the conditions of the town board properly, because I was fielding questions and writing down other conditions while everybody was talking. So,
I think the buffering,
okay, so
consistent with,
the first one is upon change of ownership, review of the project by the planning board and the town board for continued compliance with the town code and conditions of approval. That would be one
But
condition.
that's ownership of the company and ownership of the property
Upon
owner.
change of ownership of the company, Borrega Solar Systems, or property owner. So the next condition was,
Forever green vegetation, and I use the word dense. Is there more appropriate? Is there a better legal term?
I think buffering consistent with the landscape plan with continuous live vegetation, forever green,
Hold on.
dense, and sufficiently high. That's kind of what we
I
thought.
do like that, if you could go a
Okay.
little slower on that.
Buffering consistent with the landscape plan with continuous live vegetation, forever green, dense, and sufficiently high,
Hold on one second. Continuous live vegetation, forever green,
right? Dense and sufficiently high, and being sufficiently high to cover the height of the fence.
and sufficiently high to cover height of fence
red line, sideline.
and sightline of solar arrays.
Right.
Right.
So, okay, I'm sorry, so with continuous live vegetation, forever green, dense and sufficiently high to block the view of the fence
And solar array.
and solar array from
Ground level.
ground level.
Realizing that will not be high and dense the first year. you know, take time for Mother Nature to do her duty.
3, if Mr. Lanning could read that condition again, that he